Thank you, everyone, for being here. We have to wait a couple minutes just for some more members to show up. We just finished votes, so I appreciate your patience. The Subcommittee on Interior, Energy, and the Environment will come to order. Without objection, the Chair is authorized to declare recess at any time. I appreciate everyone being here with us today. Good afternoon. The Subcommittee on Interior, Energy, and Environment is meeting today to answer calls from farmers, ranchers, and rural communities to address the problems generated by special interest environmental litigation and statutes that incentivize it. During previous hearings, the subcommittee has heard from a number of witnesses across the country who have described how the court system has been used to restrict access to federal land, obstruct infrastructure development, and stifle responsible use of our natural resources. Unfortunately, many Montanans are already familiar with this problem. Serial plaintiffs and special interest groups have used litigation to threaten our Montana way of life by thwarting efforts at responsible forest management despite the threat of catastrophic wildfires, and deny our communities access to surrounding resources. For example, the critical Lower Yellowstone irrigation project almost fell victim to such extremist litigation. Over a decade ago, Congress authorized improvements to the Lower Yellowstone project, which serve 400 family farms as they rely on it for their source of water, and over 50,000 acres of cropland. However, this did not stop special interest organizations from filing suit against the diversion dam and a bypass channel designed specifically for the pallid sturgeon, repeatedly delaying the project. Fortunately, after a legal battle that reached the United States Court of Appeals for the Ninth Circuit, a district court judge allowed the project to move forward. During this delay, I worked with my colleagues in Montana and North Dakota to keep the Army Corps of Engineers and the Bureau of Reclamation moving on this critical project. Additionally, I joined Representative Jason Smith in offering an amendment to the FY19 Interior Appropriations Bill to block the sue and settle practice under the Clean Air Act, the Clean Water Act, or Endangered Species Act. Our amendment was adopted as part of the House bill, and we're waiting on Senate action. Having heard the impact of environmental litigation at our previous hearings, we will focus our attention today on additional opportunities for reform. We will pinpoint provisions of our environmental laws that are vulnerable to misuse and stages of the legal process that can be manipulated by special interests. We will also learn more about fee-shifting statutes that reward litigious organizations for suing to oppose federal agencies' missions with which they fundamentally disagree. In particular, many Montanans have shared with me their concerns about the abuse of the Equal Access to Justice Act. Congress passed EJA to enable small businesses and individuals to challenge wrongful government action despite a disparity in resources. It's an important tool to ensure Americans receive Social Security benefits and Veteran Administration benefits they deserve. Today, however, wealthy environmental organizations take advantage of the law's loopholes and exemptions to obtain large fee awards from our federal agencies. In these cases, this is an abuse of taxpayer dollars, and it's a burden on agencies that are already devoting considerable resources to guarding against and responding to litigation. By more closely examining EJA, as well as the way courts have interpreted it, I hope we can identify reforms that minimize the potential for misuse while preserving access to our court system when the government does make a mistake. I want to thank our witnesses for their time today and for their contribution to this conversation on this important topic. In particular, I'd like to thank Commissioner Mark Peck and the rest of the Lincoln County, Montana Board of Commissioners Commissioner Peck had planned on being here today, but was unable to make it due to an illness. I appreciate his willingness to travel across the country to participate in the hearing and will include his written testimony as part of the hearing record. Commissioner Peck and the other residents of Lincoln County have personally experienced how special interest litigation can halt forest management efforts and those that enjoy support, even those that enjoy support from many stakeholders. Lincoln County contains a significant amount of national forest land, and special interest litigation in such communities can be a tremendous obstacle to economic prosperity and a threat to public safety. I look forward to continue my work with the Lincoln County Commissioners and the people of Lincoln County on this issue and in the future. Thank you all again for being here, and I look forward to a great discussion. At this time, I'd like to recognize the ranking member of the subcommittee, Ms. Plaskett, for her opening statement.
Thank you, Mr. Chairman, for holding this hearing. Excuse me. In America, all people, regardless of their wealth, must be able to obtain justice in our courts. It's a principle that's embedded in the Constitution. It's a promise that's been affirmed in major Supreme Court rulings, such as Gideon versus Wainwright. It's in the meaning of the phrase equal justice under the law, which is engraved on the west pediment of the Supreme Court building. One way that Congress has innovated to ensure all people have equal access to the courts in order to prevent wrongful action is to break from the American rule where each party bears its own cost in litigation. Instead, we allow prevailing parties in certain important circumstances to recover attorney's fees in their lawsuits against the government. One of these fee-shifting statutes is the Equal Access to Justice Act. As Ms. Colangelo states in her written testimony, I quote, "EAJA enables small businesses, individuals, and nonprofit organizations to hold government agencies accountable for unlawful actions and inactions. EAJA plays a vital role in our judicial system, and not just for environmental cases." It also in her written testimony, according to the report by the Government Accountability Office, I quote, "Veterans' disability cases and Social Security disability claims represent 98% of EAJA fee applications." 98% go to veterans fighting for disability along with Social Security, those individuals who really need the support. This is long settled practice and should not be controversial. So I hope that the real agenda of today's hearing is not to undermine the principles of equal justice under the law or Congress's commitment to ensuring access to the courts. Critics say that environmental groups are suing too frequently, receiving too much of the fee recovery, and are changing the priorities of federal agencies through their litigation. But these accusations are false. Let's look at the evidence. According to a 2011 report by the GAO, most of the cases filed against the EPA were brought by trade associations and private companies, not environmental groups. Another report by GAO found that deadline suits, which compel federal agencies to take required action, such as issuing rules on time, have only a limited effect on the EPA. And this effect was only to the timing and order in which rules were issued, not the rules themselves. The Administrative Conference of the United States has also done reporting on the amount federal agencies are paying in attorneys' fees towards EAJA. According to the data presented in the report, attorneys' fees were awarded to a much greater degree in cases involving veterans' benefits and Social Security benefits than in environmental litigation. In fact, in 1 year, attorneys' fees awarded by the Department of Veterans Affairs and the Social Security Administration were 23 times greater than fees awarded by EPA and the Department of Interior. I believe these numbers speak for themselves. As a former prosecutor and attorney at the Department of Justice, I know that as hard as my fellow federal government attorneys try, there simply are not enough of them to prosecute every case of injustice. So we also need private attorney generals to bring cases to ensure the laws Congress passes are enforced. The groups and individuals who bring these cases under EAJA only recover their attorney's fees and costs when a judge has found that the government was in the wrong. And importantly, when the judge finds that the government was not substantially justified in its position. That is, as it should be. These litigants are enforcing the law and doing a service for the public. Everyone benefits: the directly affected individuals, their families and communities, people across the country who are facing similar challenges, but who will now be better off because of the corrective action by the federal government and even the losing federal agencies, which are now incentivized to fix what was broken in order to avoid further litigation. Thank you, Mr. Chairman. I look forward to the testimony of our witnesses.
Thank you, Ms. Plaskett. I'm pleased to introduce our witnesses at this time. We'll start Mr. Jonathan Brightbill, Deputy Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Department of Justice. Mr. Lawson Fite, General Counsel for the American Forest Resource Council. Ms. Sarah Colangelo, Environmental Law and Policy Program Director and Visiting Professor of Law at the Georgetown University Law Center. And last but not least, Mr. Ryan Yates, Director of Congressional Relations at the American Farm Bureau Federation. Welcome to all of you. Thank you for joining us and traveling to be with us. Pursuant to committee rules, all witnesses will be sworn in before you testify. Please stand and raise your right hand. Do you solemnly swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? The record, please be seated. The record will reflect that the witnesses answered in the affirmative. In order to allow time for discussion, please limit your opening comments to 5 minutes. Your entire written statement will be made part of the congressional record. As a reminder, the clock in front of you shows your remaining time. A light will turn yellow when you have 30 seconds left, and the red light comes on when your time's up. The microphone does not operate automatically. You have to actually turn it on. So please do that so we can hear you. And at this time, I'd like to recognize Mr. Brightbill for your testimony.
Thank you, Chairman Gianforte. Thank you, Ranking Member Plaskett. Thank you, members of the subcommittee, for this opportunity to discuss this important topic. I have the great privilege to serve as Deputy Assistant Attorney General in the Environment and Natural Resources Division in the Department of Justice. The division has broad responsibilities, enforcing the nation's civil and criminal pollution control laws, representing the United States in matters concerning the stewardship of the nation's environment and natural resources, wildlife, and public lands, and litigating cases concerning the resources and rights of Indian tribes and their members. I personally supervise a stellar team of lawyers and other staff responsible for defending rulemakings and policies arising under a broad range of pollution control statutes and for acquiring property on behalf of the federal government. The division routinely handles attorney fee claims. Congress has authorized private party litigation against federal agencies and has generally established 2 avenues by which opposing parties may seek the payment of attorney's fees through taxpayer dollars in environmental cases. First, the citizen suit and judicial review provisions in most environmental protection and some natural resources laws expressly provide for recovery of attorney's fees against the United States. Second, the attorney's fees may be payable under the Equal Access to Justice Act, known as EJA, when not available under these statutes. Under the leadership of Attorney General Sessions, ENRD is strongly committed to the rule of law and takes seriously the solemn obligation to protect taxpayer dollars. We closely scrutinize all demands for attorney's fees to ensure that they are lawful, justified, and reasonable. The division does not, however, and cannot, challenge the payment of attorney's fees in all cases. Some fee applications may be substantially justified and reasonable, but where it is appropriate to contest a claim of fees, my written statement chronicles some of our recent efforts in controlling their costs. I would like to highlight 5 recurrent challenges the division faces in handling attorney fee claims. Each is discussed in more detail in my written statement. In some areas, it seems fee litigation and recoveries may have moved beyond Congress's original intentions for providing reasonable access to the courts without encouraging excessive litigation and enriching lawyers. Federal courts are not consistent in their standards for awarding fees across the country. The 5 principles are and issues are, first, ineffective limits on hourly fee rates. Because most attorney fee provisions under environmental litigation do not contain a maximum hourly rate, we frequently see lawyers seek taxpayer-funded fee payments with exorbitant hourly rates. While EJA does contain a presumptive cap on attorney fee payments of $125 per hour plus inflation adjustment, it is subject to enhancements based on special factors and often is enhanced. In our experience, courts routinely award EJA fees at more than $500 per hour and to as high as $700 per hour. Second is the issue of no case caps. Most statutes under which ENRD litigates do not contain a maximum amount of fees the United States will subsidize in any given case. The Division has paid a number of multi-million-dollar attorney fee awards in the past 10 years. Third is low eligibility requirements. Under EJA, large tax-exempt organizations with net worths exceeding $200 million can be eligible for and have received taxpayer-funded fees. And there are no qualification requirements at all under the environmental protection and natural resource statutes noted in my written statement. As the D.C. Circuit has recognized, Congress did not intend to subsidize the purchase of legal services by large entities easily able to afford legal services. Yet many organizations are funded by outside contributions and do not require the taxpayer subsidies they receive. Fourth is the issue of fees on fees. Because parties can recover attorneys' fees for seeking payment of attorneys' fees, there is incentive for the parties to claim exorbitant fees and then litigate the issue. In deciding whether to challenge a claim for attorneys' fees, the Division must weigh the cost and risk of the prospect of fees on fees if it is not entirely successful in opposing an attorney fee application. Fifth is the inconsistent burden of proof. The United States is frequently successful defending litigation. However, courts have inconsistently interpreted the facially neutral language of attorney fee provisions to more readily permit attorney fee payments to prevailing plaintiffs rather than the United States. Addressing these challenges would enhance the consistency, predictability, transparency, and efficiency of fee awards under the environmental statutes. I thank you for your attention and would be happy to answer any questions you have concerning these challenges.
Thank you, Mr. Brightbill. At this time, I recognize Mr. Feit for his comments.
Thank you, Chairman Gianforte. Chairman Gianforte and Ranking Member Plaskett and members of the subcommittee, thank you for holding this timely hearing about imbalances in environmental litigation and potential common-sense solutions to those imbalances. Such reforms can make a significant difference in the ability of federal land managers to carry out their mission to restore forests to health and provide needed support to rural economies. At the American Forest Resource Council, AFRC, we work with federal agencies to achieve these goals through land management projects such as timber sales. Our members, loggers, sawmills, and affiliated entities, and field staff put substantial time and effort into making these projects effective and legally sufficient. Where feasible, we work with collaborative groups, including environmental organizations, to come to consensus on land management goals. And these collaborative efforts can take years, but can also bear fruit through substantial restoration projects. While we respect the need for impartial review of projects, the current legal landscape overly empowers fringe groups through a set of, in essence, default options that enable a project to be stopped without a showing of legal insufficiency. The current attorney fee system also encourages excessive environmental litigation. I want to highlight two areas where the dispute resolution system has become off-kilter and is unduly encouraging obstruction. These are administrative protest regulations and disproportionate attorney fee awards. The first involves situations where projects are held up or may even burn up, not because of any substantive fault, but because of delays in decision-making. And disproportionate fee awards encourage widespread litigation, since one fee award can cover the effective cost of many cases, even if if those other cases are not successful. The Bureau of Land Management's protest and appeals process is one area badly in need of reform. The BLM regulations permit any party to file a protest within the 15 days of the announcement of a timber sale. And there's no deadline for BLM to respond to that protest, although it has a policy of responding within 45 days. Unfortunately, that policy is often laid aside, and responses can take 18 months or more. And fringe opponents have developed a strategy of protesting every single timber sale that the BLM offers. And we had a timber sale called Picket Hog, which burned this year, and it shows how out of balance this process is. That sale covered 318 acres in Southwest Oregon, and it was aimed at reducing hazardous fuels and providing timber to support public services and jobs in that region. And despite that small size of 318 acres, that project would support retain 40 forest sector jobs. That's the equivalent of a full shift at a mill. That was sold to a timber company in Oregon last September of 2017. A protest was filed, and if it had been processed timely, it was likely could have been harvested this year. But the protest was not responded to, and the Taylor Creek fire came through and burned that timber sale this summer. That's the type of situation that undermines faith in our decision-making processes, in our agencies, and in our courts. Attorney fee awards have become disproportionate to the work performed, as the courts are simply not providing sufficient constraints on attorney fee requests. A few examples here. The Oregon District Court recently awarded over $180,000 in attorney's fees for a case that involved a single motion for a preliminary injunction and one motion hearing, $180,000. In another case, the same court awarded over $800,000 for a case that went to the merits but only on briefing, and there was no trial, and it did not involve discovery on unusual motion practice. And in the East Reservoir litigation, which affects Lincoln County, Montana, even though the appellants and plaintiffs obtained relief applicable to only 20% of the project, they've still requested over $200,000 in fees. We look forward to discussing with you this afternoon ways in which we can reform our environmental litigation system and restore balance. Thank you.
Thank you, Mr. Feit. And at this time, we'll recognize Ms. Colangelo for her testimony.
Thank you, and good afternoon, Mr. Chairman, members of the subcommittee, and staff. It's an honor and a pleasure to testify here today. My name is Sarah Colangelo, and I work at the Georgetown University Law Center in two capacities. First, as the director of our environmental law and policy program, and second, as a professor teaching multiple environmental law courses. I'm speaking here today in my personal capacity, and my remarks are my own. Before joining Georgetown Law, I had the distinct honor to serve in the Department of Justice in the Environment Division for about 8 years. Thank you for inviting me here today to speak with you about the critical questions of the import and utility of certain types of environmental litigation. The statutes that appear to be at issue here, the Equal Access to Justice Act, the National Environmental Policy Act, and others, and including citizen suit provisions in general, are extremely critical to the efficacy of our environmental regulatory system. Citizen, small business, and organization-based litigation advances key societal goals articulated by Congress through our statutes. This litigation keeps government agencies accountable when failing to follow a congressional or statutory mandate or acting arbitrarily or capriciously or contrary to law. We need private citizens and organizations to continue to bring environmental suits, both because government action can't solve every problem, and in some cases, government action or inaction is the problem. The unsupported rhetoric of abuse and frivolous lawsuits is a threat to these goals. It's a threat to all citizens and groups for whom EJA is their only hope of fee recovery. Of note, more than 90% of these petitions are brought by veterans groups and Social Security disability claimants. Indeed, EJA articulates a logical principle. individuals, small businesses, and nonprofit groups that prevail against the government, and where the government can't substantially justify its legal position in law or fact, should be able to recover reasonable attorney's fees and litigation costs. In examining what little publicly available data we have on EJA, we see that the data do not support the allegations made by my counterparts. In the aggregate, the data show how minuscule environmental EJA awards really are compared to agency budgets, in the small amount of cases where the fee award actually comes from the agency budget. And they show how low fee rate recovery actually is. Further, from the perspective of pure logic, these assertions fail. In light of EJA's unique characteristics among fee-shifting statutes, and we have many of them here in the United States, the difficulty of prevailing on a claim for EJA fees in the first instance, as I described in my written testimony, and then the below-market rate recovery, EJA is considered a last recourse for plaintiffs. Simply put, there is far too much risk for far too little financial gain for EJA to act as any type of inducement for abusive or frivolous lawsuits. I want to reiterate how important fee shifting is, especially in the context of public interest litigation. Given that any changes to fee shifting provisions could have wide-ranging consequences, beyond the very discrete instances we're talking about here today, a subset of environmental cases, which in and of themselves are a tiny subset of EJA cases, I hope to encourage the subcommittee through my testimony to make recommendations based on empirical evidence, not assumptions and not anecdotes from a particular geographical area, a particular government agency, or a particular subset of disfavored plaintiffs. As Congress itself recognized in passing EJA, EJA rests on the premise that a party who chooses to litigate an issue against the government is not only representing his or her vested interest, but is also refining and formulating public policy, and adjudication or civil action provides a concrete adversarial test of government regulation and thereby ensures the legitimacy and fairness of the law. As we move forward today talking about these statutes, their purposes, and their implementation, and considering various changes to these statutes, I urge the committee to remain mindful of the risks of making broad changes that could have a chilling effect on public interest litigation more broadly, and that could close the court doors to those whose last recourse is our judicial system. Thank you.
Thank you for your testimony, Ms. Colangelo. And now I recognize Mr. Yates for his testimony.
Chairman Gianforte, Ranking Member Plaskett, and members of the subcommittee. My name is Ryan Yates, and I'm Director of Congressional Relations at the American Farm Bureau Federation. I'm pleased to be here today and would like to devote my time primarily to explaining how the use of federal fee-shifting statutes has deviated from Congress's intent specific to issues of transparency, fairness, and cost to the taxpayer. EJA and other fee-shifting statutes were intended to rebalance the scales and restore equity to the David versus Goliath task that individuals and small businesses and organizations take on when suing the federal government to vindicate their rights and hold government accountable. Congress wanted to make it possible to challenge an unjust cost or penalty or an unjust denial of hard-earned benefits without paying more in attorney's fees than what an individual would stand to lose or gain in litigation. But almost 40 years on, the result is anything but equitable. When EJA was first enacted, Congress required tracking of attorney's fees paid out of agency budgets for both litigation and administrative proceedings. That requirement ended in 1995. Today, federal agencies simply have no mechanism for tracking how much they were paying. Other fee-shifting statutes are not meaningfully different in terms of transparency. Citizen suit provisions in many environmental laws allow for fee shifting, though those fees come out of the judgment fund. Only recently has the judgment fund begun posting information regarding how much money it pays out each year, including attorney's fees. For example, in FY 2016 alone, the judgment fund paid out over $3.8 million in attorney's fees just for environmental litigation. The information provided does not include any indication about the outcome or merits of the litigation, or whether the plaintiff was an individual seeking justice or an advocacy organization with a policy agenda. One solution would be for Congress to restore reporting requirements to track and report attorney's fees paid in litigation, as it has previously attempted to do in the Open Book on Equal Access to Justice Act and the Government Litigation Savings Act. Reporting should be easily available online, and should include information regarding the outcome of the litigation and who was deemed the prevailing party and why. Both the terms of EJA itself and the way courts have interpreted it have overwhelmingly favored environmental groups in terms of their ability to recover attorney's fees. One problem is that EJA preferences 501c3 organizations over other nonprofits. Currently, EJA allows only entities with a net worth of up to $7 million and with fewer than 500 employees to recover attorney's fees, with one caveat: 501c3 organizations. The exception means that environmental groups funded by millionaires can get taxpayer dollars to sue the government, whereas those millionaires would have to pay if suing on their own. Nonprofit groups such as Farm Bureau, however, do not qualify for this treatment. One solution would be to remove the 501c3 exception. Small environmental and other organizations that truly cannot otherwise bring suit could recover if successful on the merits, but others, such as the Center for Biological Diversity, which ended 2016 with net assets of over $19 million, and in the span of 10 years filed over 400 district court cases, rightfully could not. EJA provides a fixed hourly rate of $125, but only unless the court determines that a special factor justifies a higher fee. Courts uniformly recognize that environmental law requires special skill, allowing attorneys to recover well above the statutory amount. One solution would be to remove courts' discretion to adjust the rate and set a fixed, possibly higher rate. These changes could be applied to all fee-shifting statutes, not just EJA. Another problem is that taxpayers are paying environmental groups for the government's routine failure to meet arbitrary deadlines. For too long, environmental groups have made a cottage industry out of suing agencies such as the U.S. Fish and Wildlife Service when it misses a deadline to act. Deadlines it cannot possibly meet given the short statutory period and current level of federal funding. No environmental organization should be able to profit from this situation, and agencies should set policy based on Congress's directives, not private litigants' interests. We recommend barring attorney's fees for deadline suits. The American Farm Bureau Federation appreciates the committee's willingness to listen to these concerns. The need for continued oversight and reform of environmental litigation cannot be overstated. Farmers, ranchers, and small businesses suffer when environmental groups make them pay on both sides of the litigation. We look forward to continuing to work with you in pursuing solutions to the problems I have highlighted today. Thank you.
Thank you, Mr. Yates. Well, now committee members will ask questions, and I'll begin. If I could with you, Mr. Brightbill. What is DOJ's role when agencies such as Interior or USDA are sued, and how does DOJ handle the fee awards in those cases?
So it depends on the particular environmental statute that is at issue and whether it is one of the statutes with a specific attorney fee provision or if it's one that's simply pursuant to the APA. So it's going to vary. As I've described in my oral testimony, there's two different regimes ultimately that might come into play. And our role is to defend the lawful decisions of our agencies, and at the point at which the defenses may be held to not be sufficient and a judgment or a decision has been rendered, attorney fee applications are then submitted to the Department of Justice, and we also share and collaborate with our agencies on those fee applications. We then carefully review those fee applications, and this has been a point of emphasis for the Environment and Natural Resources Division for a long time, but we've redoubled our efforts under the leadership of Attorney General Sessions to really focus on this issue, scrutinize the bills, the statements, the rates, and where we can, we try to negotiate to an outcome or a solution because of the inconsistency, the lack of predictability, the differences in standards. Litigating attorney fee disputes is, frankly, a risky proposition for the Department of Justice. And because of this issue of fees on fees, even where we are substantially successful in reducing fee amounts, we can also often end up costing the taxpayers additional dollars in attorney fee awards for the Department of Justice for having fought against an excessive or exorbitant attorney fee award.
And what steps does DOJ take now to safeguard taxpayer dollars in this process?
So what we do is, it is a practice to require and ask wherever we can, and sometimes litigants won't give us their billing records and they just want to proceed to litigation, but we try to obtain the billing records that, just like any private law firm, even from environmental groups and the like. We scrutinize those bills. We look for instances of double billing. We look for instances where the rates that are being claimed are inconsistent with the geographic locale where a given attorney may be located. We look for instances of double billing, of inefficient activity. And then our practice is to, frankly, try to negotiate and see if we can reach an accommodation because of the litigation risk of proceeding with these things. If we cannot, we will then fight it in court.
So are there instances where people are applying for legal fees under equal access to justice, but they won't give you the billing records?
We have had those types of instances that they will not provide the billing records. Now, ultimately, if they're going to go into court, very often a court will require some sort of declaration or other statement. But it varies. It's very inconsistent from court to court. There aren't clear standards as to what a court needs to do ultimately to adjudicate these decisions. And so outcomes are all over the map.
Would you characterize the environmental statutes we have on the books today, like Endangered Species Act, plaintiff-friendly?
I don't know that I would characterize them as plaintiff-friendly. The environmental statutes are used by both all types of organizations. So I guess it depends who the plaintiff is going to depend in any given case. I would characterize them as this, is that there are a number of provisions in them that are inconsistently applied across the various circuits and districts. It makes it very difficult to predict what outcomes would be and have generated tremendous inefficiency.
Okay. Mr. Yates, we spoke earlier about the cap that Congress included in the statute. In your experience, is there a meaningful cap to EJA awards?
You know, in terms of, currently the statute calls for a $125 cap. I think the issue that we have, certainly looking back, a lot of time has passed since that rate had been put into the statute. Certainly Congress could look at that and come up with a fair hourly rate based on 2018. But in terms of making a recommendation, we certainly would leave that to Congress. But I think that our primary concern is the fact that the courts are the ones determining the hourly rates rather than the defined $125 cap.
And in your experience, do they abide by the statute today, or are there deviation?
Again, because of the exception in the law, the judge can award hourly rates at a higher rate. Again, I think the gentleman mentioned upwards of $500 to $700 an hour based on the fact that environmental law is considered a specialty.
Yeah, and Mr. Feit, you've served as a fee expert on some of these EJA cases. Could you share your observations on this fee setting?
Absolutely, Mr. Chairman. There are a number of observations that I have. One of those is that by the time a fee expert needs to be brought in, you're already in litigation. So already the efforts that Mr. Brightbill was referring to reach an accommodation have failed. And then at that point, there's very little incentive for a fee applicant to trim back their billing requests in any meaningful way, because the more they request, the more they're likely to get. The courts are generally reluctant to impose meaningful limits on those fee requests, particularly in a number of areas. One of those is courts are very hesitant about imposing any sort of reduction that has to do with the level of success that was achieved in a litigation or the complexity of that litigation. They tend to award a rate that's commensurate with high-level commercial litigation rates.
Mr. Feit, my time is expiring, so we're going to continue the questioning here, but I need to
Very well.
recognize the ranking member, Ms. Plaskett, for her questions.
Thank you. Thank you very much. Thank you all for being here, and thank you for the work that you're doing. Mr. Brightbill, thank you for your service and coming out of private practice and coming back to work with the government. I worked for several years at the Department of Justice and worked for the Associate Attorney General, and I know how hard you all in ENRD really do put in some tremendous work. The staff attorneys, the attorneys there really are great people, and, you know, fortunate for those of us who are the Christmas help, only there as political appointees for a period of time, really rely quite heavily on the career people who are there. I wanted to ask you, when we talked about the some of the questions that were here previously that have been asked of you, is there a difference between putative damages that individuals may seek and seeking attorney fees? And if you can enlighten the committee on what that difference is.
Sure. I mean, it obviously depends on what regime we're talking about here. We're focused on environmental environmental cases here in this context.
Sure.
And sure, and you can receive punitive damages in under certain of the environmental statutes or tort statutes or whatever the case may be. And those are damages that are intended to actually punish the defendant for what it is. An attorney fee provision is generally speaking and understood based on the legislative history of the Congress at the time that they were put into place, thought to provide some level of compensation and support on the actual fee component that were incurred in order to obtain justice or obtain result. So that traditionally speaking, attorney fee provisions aren't thought of as something that is meant to punish an agency or a defendant in any way. And in fact, you know, that's sometimes offered as a justification for why these provisions should be in effect vis-a-vis the federal agencies that I defend at ENRD. But interestingly, there is findings of the GAO and other places. In fact, it's been referenced in some of the other testimony from some of the other witnesses here, that the GAO has found that because fees paid out are so relatively small across the entirety of the agency budgets, that these payments are of little value and are not even needed for internal agency management of their purposes. So on one hand, there's a contention that these fees are serving some sort of purpose of incentivizing the federal agencies to comply with their obligations under federal law, but on the same hand, people are saying, well, they're not really a big deal, they don't really affect their budget, so we don't have to worry about the effect they're having on the taxpayers.
And so where do you fall?
What's that?
Where do you fall?
So where it's not just
On that pendulum, where do you fall?
Yeah, at this point, the fee awards seem to be inconsistent in their application and under the current statutes, that if you go from place to place across the country, depending on what the courts are, you can get very inconsistent and unpredictable results. And so I guess what I would suggest is, if the policy here is that we want to have attorney fees in place to punish agencies so they feel some of the pain, well, ultimately, then the data that's been cited to this committee reflects that it won't even do that. So you're providing taxpayer dollars in subsidy towards a policy that won't even achieve its objective of punishing the agencies.
Okay. You know, I recall that may not be the case in instances where you have a very a plaintiff who has the wherewithal and the means to be able to support, but when you have individuals such as when we discuss, not in the environmental instance, but other instances which use it more, veterans or disability or Social Security, recognizing that that is needed to incentivize attorneys to even potentially take the cases. So, Ms., and please tell me how to pronounce your name appropriately. Colangelo, in your time at the DOJ, the 8 years that you were there, and working in ENRD, how do you find the use of the attorney fees in terms of the determinant for whether or not litigation was taken on?
Well, let me try to answer your question briefly as I see the yellow light. So during my time at ENRD, I was an affirmative litigator working in the environmental enforcement section. So because I wasn't in a defensive position, I was not litigating, didn't have the opportunity to litigate EJA firsthand. However, I would say that that as an affirmative litigator, I can tell you that in determining whether or not to bring a lawsuit, this type of small award would factor in very little to a decision as to whether or not to bring a lawsuit, and that's based on my time in terms of designing and strategizing enforcement cases, but also in talking with small enforcement groups like our clinic at Georgetown Law.
And what evidence is there that EJA incentivizes plaintiffs to bring frivolous lawsuits?
I don't believe there is evidence to
And is there
support that
evidence
claim.
that their federal agencies are financially burdened by the attorney fees awarded under EJA?
No, in fact, the evidence points the exact opposite
And
way.
what do you mean by that?
So, for example, as was cited by Mr. Brightbill, the awards, the fee awards are so minuscule that the agencies don't even track them for their internal purposes and their budget planning. So this is not substantially burdensome to the agency. And for example, just to give you some additional data, in 2010, the United States Fish and Wildlife Service spent 0.5% of the entire agency budget devoted to endangered species work on litigation. This is an extremely small amount, a fraction of a fraction that they're spending on this.
Thank you. My time is running, has long expired, and I thank you for the indulgence. I yield back.
Yeah, thank you. At this time, I'd like to recognize the gentleman from Texas, Mr. Cloud, for your questions.
Thank you, Chairman. Hello. In your experience with cases involving requests for EJA fees, Mr. Fite, do you believe that there's any shortcomings with the current process in determining hourly rates for the purpose of EJA awards? Or would you suggest any changes to make these awards more reasonable?
Yes, Congressman. I think there are ways to make the hourly rate determination process work better, particularly under EJA, but also under the other environmental fee shifting statutes. The courts tend to award rates that are commensurate with high-end commercial litigation rates in large cities. And that's simply not reflective of the market for these legal services. There are a number of ways that we can address this issue. One is the disparity between courts where the Ninth Circuit, almost as a matter of routine, will determine that environmental law is a specialty justifying deviation from the statutory rate, which with inflation right now is $193. And that rate in general is sufficient for most practitioners to get compensated but not receive a windfall.
Do you believe that more guidance on how to apply the statutory cap in favor of special exemption from Congress would be beneficial?
Yes, Congressman. If EJA were amended and perhaps some of the other fee-shifting statutes to direct that there would be no deviation from a cap, or that it would be an exceedingly rare instance, then you would see fee applications and fee awards be a lot more proportional or resembling much more what you would see a private party or a private client pay for those services. And what we see is the value of legal services that's being provided is out of proportion to the fee awards. And courts are reluctant. Not all courts have a lot of experience in determining rates. And there have been a lot of changes in how the legal market operates. There's been a lot of disruption over the last 10 years, and consumers of legal services are really smart shoppers these days. And so the taxpayer should not be stuck holding the bag when the market is showing how to do this, how to get legal services at a really efficient rate.
Thank you. I yield back. Yield my time.
Okay, thank you. At this time, I'd like to recognize the gentleman from Arizona, Mr. Gosar.
Thank you, Mr. Chairman. Mr. Yates, the money that attorneys make from litigation, and I'm not referring to the recouping of fees expended, but the actual fees collected in excess of expenses by outside groups, where does it go?
Where does it go?
Hmm?
When EJA funds reimburse? Well,
To their pockets, right?
Sure, back to the attorneys or the firm.
Now, I'm kind of familiar with nonprofits because I headed a nonprofit for a couple of years. And so, nonprofits are actually rated on behalf of a percentage of every dollar that goes to their mission statement. For example, it's rumored that the Clinton Foundation gave 6 cents of every dollar. Not very efficient, whereas the Arizona Dental Foundation, which I was part of, was over 90 cents out of the dollar. Can you think of a better way of using that money?
In terms of environmental NGOs? Well, certainly, I think we'd like to see more efforts to expend those dollars in actual conservation than in legal.
That's exactly what I thought. We had this conversation yesterday in natural resources. And we were told that what ends up happening, we're behind the 8 ball in species going extinct. So it seems like what we ought to be doing is incentivizing expected outcomes on behalf of the endangered species. Wouldn't you agree?
Certainly.
Now, Mr. Brightbill, there's a wide variety of typical attorney rates depending upon how different circuits you alluded to Mr. Fight actually alluded to the Ninth Circuit, have ruled previously. Do you see any issues with the lack of standardization rates for attorney's fees in environmental cases?
Absolutely.
Now, Mr. Yates, this morning we passed H.R. 3608, the Endangered Species Transparency and Reasonableness Act, introduced by Representative McClintock through the Committee on Natural Resources. This bill requires the Fish and Wildlife to track, report to Congress, and to make available online. Number one, funds expended in response to ESA lawsuits. Number two, the number of employees dedicated to litigation. And three, attorney's fees awarded in the course of ESA litigation and settlement agreements. The bill also requires the federal government to disclose to affected states all data used prior to any ESA listing decisions, and require that the best available science and commercial data, end quote, be used by the federal government, include data provided by affected states, tribes, and local governments. Finally, this bill prioritizes resources towards species protection by placing reasonable caps on attorney fees. Would you agree that this bill is badly needed?
Certainly, I think it's a very important bill. I think when you're looking at issues of good government and transparency, the provisions within that bill, and certainly some of the issues that we're being discussed today, I think are important for not only the issue more broadly, but certainly in terms of taxpayers' right to know. I think it's important to fully understand what's necessary to reform fee shifting statutes. I think taxpayers need to know exactly where their money is going.
So, Mr. Brightbill, Ms. Colangelo brought up a percentage, and that's kind of deceptive. So that percentage of the budget, can you give me a range in that? Is it like $1,000, or is it millions of dollars? What is hundreds of millions of dollars? What is that number that we settlement in litigation?
I don't know the precise numbers. I know that there have been references to particular areas for example, I believe it was Montana, in the testimony that was submitted by the Forest Service referred to recoveries around $350,000 for last fiscal year. Now, that just would have been one region.
Just one region.
One region of one agency.
So it can be very deceptive at the percentages. I know, I'm aware of the mathematics on how to present that. Mr. Yates, do you think that plaintiffs misuse NEPA in bringing legal challenges to agricultural activities?
Certainly, it's a challenge, and I think it's well due for reform.
So would there be any changes that you would recommend to the NEPA process to reduce its vulnerability to exploitation by special interests?
I think anytime you can, I think the biggest issue is the impact of litigation on getting federal practices and projects done. Certainly when you're looking at projects put in place by the Bureau of Land Management, or the Fish and Wildlife Service, the Forest Service, oftentimes you see litigation being used to halt projects or delay projects, which ultimately have an impact on the rural economy. And so
it'd be nice
finding
like
ways to find efficiencies to streamline and reduce the impact or the risk of frivolous litigation is certainly
like a best management practices.
Certainly.
Yeah. Thank you, Mr. Chairman.
Yeah, thank you. I would like, again, thank the witness. I want to do one last short set of questions just to focus on outcomes, because the purpose of these oversight committees are really to look at where do we go from here. And if you don't mind, Mr. Yates, I'd like to start with you. Based on your experience with the work you do at the Farm Bureau, what should Congress do to improve the situation?
Well, I think a hearing like this is timely, and I think being able to provide oversight and look into these issues is first and foremost the most important thing that you can do today. Looking at expanding on efforts currently underway. I know previously in the first session of this Congress, the House passed the Open Book on Equal Access to Justice Act. I think that's a bipartisan bill that really focuses on providing transparency in the process, and I think that's a great first start to look at bipartisan pathways forward, and certainly we'll be working with our friends in the Senate to move that bill forward. But certainly that's just the beginning. I think, there are other issues and solutions that I provided in my oral remarks, but certainly there are other issues that we believe warrant continued oversight by the committee, possibly looking at additional statutory changes. One being issues concerning the prevailing party requirement. We believe that exceeds reasonable bounds. Certainly tightening that definition, I think, would be something that we'd encourage the committee to look at. Another issue is the state and federal parity as it pertains to EJA. EJA is unavailable in certain state courts. We had an example in the state of Idaho, stock water rights dispute between the BLM and 2 Idaho ranches filed in Idaho State Court. BLM's position ultimately was wrong, and they appealed all the way up to the Idaho Supreme Court, where they lost. Unfortunately, the Idaho Supreme Court did not award ranchers attorney fees under EJA. That's an issue that I think warrants additional look by this committee. Certainly, Congress could explicitly waive sovereign immunity for attorneys' fees against government in both federal and state litigation. I think with just a few words, Congress could restore parity in that particular situation. But again, these are the types of things that I think are important, and continued dialogue is something that we are more than willing to have with this committee, and we appreciate your time.
Ms. Colangelo, I agree with your statements. We need to preserve this for individuals that are seeking veterans benefits or Social Security, and I made those comments in my opening statements. In your mind, are there things we can do to make EJA better?
Yes, thank you, Mr. Chairman. I agree with what my colleagues are saying with regard to ways, the best way to move forward here is to collect information. When we do that, we make what's going on with EJA more transparent, and likely you would end up with more consistency in that case. So I agree on that. I think there should be increased EJA tracking. I think there are ways to do this. If I'm recalling correctly from my time at DOJ, you fill out a form when you finish a case and you mark down injunctive relief, civil penalty if there is one, and you could certainly include space there for EJA fees. So I think there's a way to do this. I think when we see the data in front of us, we're going to come up with better solutions. But that's really the first step. And if I might provide one example of this, the Council on Environmental Quality is currently looking at potential changes to NEPA. And when they gathered data and started looking at the Department of Energy compliance with NEPA, for example, and they're looking at how long certain components of the NEPA process take. What they found actually is that lack of funding, low priority of a project, complexity of the project, changes in the scope of the project, all of these things actually fed into timing. So without really understanding, you might just look at it and say, oh, it's litigation driving these delays, but without further research, we just won't know. So my main priority would be finding that transparency. And if I might make 2 clarifying points.
Okay, I want to get to the rest of the panel members, so I could. Thank you. Mr. Fite.
Thank you, Mr. Chairman. As to where we go from here, certainly data collection and transparency is welcome and would be helpful. The committee would make progress by continuing its work and looking at rate equalization across the country. I think the fact that if you file in Washington, D.C. versus in the Ninth Circuit determines what kind of rate is going to be awarded, that just doesn't seem fair. Other things to really look at are the availability of injunctions even on collaborative projects like the East Reservoir project in Montana, where you get a whole group together and then a fringe group comes in and gets an injunction.
These are people that did not participate in the collaborative process.
Exactly. They reject the whole idea of collaboration. And so for them to get this kind of heckler's veto, it is not fair. And finally, continuing to take a look at the administrative processes, particularly the land management agencies, BLM, and the Forest Service.
Okay. Mr. Brightbill, you referenced a number of times that there's been inconsistency between regions around the country. Is there something Congress can do to fix that?
One of the things that Congress could look at is finding ways to standardize and come up with more bright line rules regarding how these things are applied and take some of the discretion out of the hands of individual courts and judges because it leads to expensive and inconsistent collateral litigation. I should be clear that the Department has not taken a position at this time on any particular policy outcome, but the division would certainly be happy to work with you or other individual members on the committee to provide technical assistance in the preparation of any legislative proposal you might want to put forth.
Okay, we would welcome your input on that. You know, again, we express the intent of Congress, but ultimately you're on the front lines in doing this. I want to thank our witnesses again today for appearing before us. The hearing record will remain open for 2 weeks for any member to submit a written opening statement or questions for the record. If there's no further business, without objection, the subcommittee stands adjourned.